Story 1. Opposing counsel. Isn't it true you hit the victim in the face with a brick? Client. No, Marcus hit him with the brick. I hit him in the back with a piece of wood. Story 2. He had sent a photo of his wife's beaten face to his wife with a message saying something along the lines of, "Do you want this to happen again?" He came across very well in court up to that point, but his mask slipped when that came out. Story 3. A buddy of mine works as a public defender. A woman was arrested on drug charges and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out she didn't have any drugs on her when they arrested her because she had just sold them to an undercover police officer. Story 4. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. The same detectives on my case and this new theft. They fingerprint the guy, and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney, and he says there's really no way to prove it. However, the tie he chose to wear was a one-of-a-kind street map of San Francisco, and I still had all the documentation to prove it. The district attorney's eyes widen, and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. Story 5. A bit late to the party, but here goes, and obligatory, not my client. The company I worked for at the time was doing due diligence before acquiring a small tech startup. The chief operating officer of the tech startup was a well-liked guy in the company, friendly and outgoing. However, we had heard rumors that the chief operating officer was rather hands-on with the work and with female employees. Apparently, there was a walkaway package proposed to the chief operating officer that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed human resources complaints against the chief operating officer and obtained counsel. I sat in on the meeting with the chief operating officer and the company's retained lawyers, while they questioned him about his contacts with the young woman. The chief operating officer denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The chief operating officer emphatically denied having any contact with her outside of work. The lawyers asked the question in several different ways, and each time the chief operating officer denied any out-of-work contact. Later, we met with the woman and her lawyer with the chief operating officer not present. Her lawyer gave us a rather graphic card that came with a bouquet of flowers addressed to her from the chief operating officer. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, "But I never had contact with her. It's not like I delivered the flowers myself." The chief operating officer got terminated for cause, so no walkaway package. At her request, the woman was given paid time off until after the acquisition, then moved to another one of the companies under our umbrella. Story 6. I am a lawyer in the United Kingdom. I acted for a member of a well-known group dedicated to catching pedophiles. My client was charged with various offenses related to his vigilantism, most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions as I am bound to do. If the state will not punish pedophiles properly, then it is left to men like my client to take the law into their own hands. An argument without merit for many reasons. His laptop was seized by police and submitted for forensic examination. It contained a staggeringly large database of child pornography. He himself was a massive pedophile. Story 7. Minor traffic cases can be the worst for this, believe it or not, because they are short and simple and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up an unplowed snow lane to get around all the other cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she claimed she'd just forgotten to mention it. Now maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consultations, give my honest assessment if the case is even worth doing, and so by omitting that detail, she harmed herself for no reason. At least she took it well and didn't get defensive. Story 8. A friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an air conditioning unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they are charging me with assault. I never touched her. I just threw an air conditioning unit at her. This is unfair." The judge rescinded the plea deal because of the defendant's attitude and lack of remorse, went to trial, and got a year in jail. Story 9. Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing, it came out that they were never a couple, that he was sending sex toys to her residence on a weekly basis, and that she never asked for the thousands of dollars he gave her over the years. We lost. He got laughed out of court and he learned a valuable lesson. Tell your lawyer the good and the bad stuff before trial. Story 10. There are so many. My friend is in a custody battle where the opposing party claims he has a drinking problem and he denies it completely. Even after the real talk I have with him, asking him not to hide anything from me and to be honest, we go into court, and at cross-examination the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few beers, and then going to pick up his child from school. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex's brother owns a private investigator firm. What an idiot. Story 11. That he filmed his offenses for his YouTube channel. The police didn't even know. A witness brought it up on day 3 of the trial. It was a nice quick change of plea that afternoon. Story 12. Employment case. We got to the deposition of my client and all set up. The first question is, please state your name. The client looks at me and says, "Can we take a break?" We do, and she pulls me out into the hall to tell me she's lied to me about her identity. She's apparently a serial fraudster and has changed identities 7 times since the 1990s. She apparently thought the other attorneys had somehow figured it out, and that's why they asked the question. Story 13. Case as a paralegal. Negligence case. Client argued that a lack of streetlights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with pornography playing on the phone. It wasn't difficult to figure out who was negligent at that point. Story 14. A man in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs and had no rule violations. His family came in and paid to get everything started. I asked the family and the client if he had requested a modification before because the law stated that for his conviction, he could only request modification twice for any one sentence, regardless of whether they were granted or denied. They swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the case record finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. Story 15. I am a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. I have been fighting to argue that the parent is stable, working lawfully, has a suitable apartment, no longer needs psychotropic medication, and is ready to be a parent, etc. After a few months of negotiating with all parties and the Department of Children and Court Services, we have a pretrial to try and convince the guardians. I meet with my client before the hearing to see if anything has changed. Nope, all good. Let's get my kids. Great, that's not happening today, but let's try. We get going in court. My client, who is very hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1. No longer working. 2. No longer in the apartment. 3. Doesn't want to have a relationship with guardians despite her kids loving them. 4. Won't send her kids pictures of the toys they miss and can't have. 5. Plans on moving out of state. 6. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant. All in a matter of 15 seconds. I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July. To clarify, my client was working really hard to get everything right and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a monster reinstated. This was a true bombshell, as I did my due diligence to make sure things were in order and statutory requirements were met. Things fell apart very fast, apparently. This was a very atypical situation. Parents typically do a really good job working hard to meet their requirements. Story 16. Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she had ever handled. Story 17. I wasn't a lawyer in this role, but I was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long, drawn-out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior, the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence and arguments, brought in experts such as land assessors, financial planning people, and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out of the courtroom. The judge had to dismiss the jury, and the couple was adamant that they didn't think that getting back together was a detail any of their attorneys needed to know. Edit: yes, in some states there are jury trials for divorces. However, this particular case wasn't for the divorce, but for a cause of action stemming from the divorce, marital property. It was a jury trial. Story 18. I am a public defender in an area with lots of methamphetamine use. Methamphetamine makes most people talk a lot. So I cannot tell you how many clients forget to mention that they got to the jail still high and called their mom, girlfriend, or buddy on the recorded jail phone and not only confessed to the crime but also brainstormed whatever alibi or version of events I am relying on to defend them. Edit. I am seeing this question a lot, so I will add some information here. This is not legal advice, just explaining things a bit more. Calls to a lawyer are privileged and generally go through dedicated lines that are not recorded, depending on the facility. Calls to family, friends, etc. through the normal phones are not privileged, are generally recorded, and can be used in court. There are usually printed signs near the phones and a recorded warning before each call that this is the case. Story 19. I heard of a guy trying to appeal his disability benefit being revoked. He was supposedly a paraplegic, but the opposition had over 10 minutes of video footage of him walking, running, and even jumping over a fence. After the 1-minute mark, the judge said, "Okay, I've seen enough. Please leave." Story 20. Credit card theft and fraud case. When I was a young lawyer back in the late 1980s, I was trying this guy on a credit card case, and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how she could be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, Because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him. The jury convicted him, and I learned that day to better prepare my clients for trial.